Good afternoon, everyone. Very welcome to this webinar on the management of sexual offenders, organized by the Criminal Justice Platform Europe. My colleague Mirka will introduce the organizing committee and the partnership that the Criminal Justice Platform is built upon. And my name is Gustav Talving. I'm director of European Organization of Correctional and Prison Services. And I'm going to be the moderator for this webinar, 2 coming hours. And I will start with a few house rules. I ask all of you to keep your microphones muted while not speaking. And all the questions that you will pose, we suggest that you post them in the chat. After each presentation, there will be a moment for clarifying questions. And Mirka will keep track on the chat, and we will try to bring some clarifications after each presentation. More complex questions we will keep until the Q&A at the end of the webinar. And that's the way to keep the time schedule of this very interesting webinar. The webinar will be recorded, and if you want to pose a question or speak and show your video, and not showing your name, we suggest that you rename yourself in the Zoom function. Again, very welcome. And with these short words of house rules, I would like to leave the word to Mirka to open the webinar.
Thank you, ladies and gentlemen. Welcome. Nice afternoon. My name is Mirka Jakešová, and I'm the policy officer with the Confederation of European Probation. Before we start with the presentations, I would like to briefly introduce the Criminal Justice Platform Europe and the organization behind the platform. The Criminal Justice Platform Europe is represented by 3 network organizations: European Forum for Restorative Justice, EuroPris, and the Confederation of European Probation. The 3 organizations together are equally represented in the platform, and each of them have a wide membership of organizations from across Europe, comprising public authorities, non-governmental organizations, academic institutions, and individual experts. All 3 organizations have a different focus in the criminal justice chain: restorative justice, prison, and probation. The platform was founded 10 years ago in 2011, when the 3 organizations decided to explore the value and commitment to cooperate on issues that are of relevance for all 3 organizations. Over the years, the platform organized a number of events, both face-to-face and online, on the themes that are of the main share points of attention, like victim rights and implementation of EU Victims Directive, violent extremism, alternatives to detention, and many others. Many events were hosted by the Center for Legal Studies in Barcelona, and important to mention is that the Ministry of Justice of Catalonia supports the platform and provides meeting and administration resources. Back in 2017, the platform started organizing so-called summer courses, and until now, these were very successful events, which took place at the beginning of July. Unfortunately, due to the COVID outbreak, the platform had no other choice but to postpone the 2nd round of the International Criminal Justice Summer Course. But I'm happy to inform you that the next round of the Criminal Justice Summer Course is going to take place next July in Barcelona from the 5th to the 9th of July 2022. The topic for the summer course is the responses on sexual violence. More details on the course, of course, will be released later, and we are, of course, looking forward to meeting you all face-to-face next summer. Now, let me introduce briefly the 3 organizations behind the platform. The first one is the European Forum for Restorative Justice, which is an international network organization connecting members active in the field of restorative justice as practitioners, academics, policymakers throughout Europe and beyond. European Forum is a non-political, non-governmental organization. It promotes research, policy and practice development so that every person may have access to high-quality restorative justice services at any time and in any case. The main focus of the forum is on the application of restorative justice to criminal matters, but on other areas such as family, school, and community mediations. Community mediation are also addressed by the forum. Last year, European Forum celebrated its 20th anniversary, and its executive director is, of course, here today with us. It's Mrs. Edith Thers, and she will deliver the closing speech. EuroPris, another organization behind the platform, is the European Organization of Prison and Correctional Services. It's a non-political, non-governmental organization which brings together practitioners in the prisons area with the specific intention of promoting ethical and rights-based imprisonment, exchanging information, and providing expert assistance to support this agenda. EuroPris focuses on cooperation among European prison and correctional services with the aim of improving the lives of prisoners and their families, enhancing public safety and security, reducing reoffending, and advancing professionalism in the field of correction. EuroPris was founded 10 years ago and has its headquarters in The Hague, the Netherlands. Executive Director, Mr. Gustav Talving, is a moderator of today's webinar, which you already know. The last organization is the Confederation of European Probation, which is also a non-political, non-governmental organization which brings together probation services from all around Europe. It unites authorities and bodies providing probation services, as well as non-profit private organizations that do not engage in probation service provision, but support, facilitate, and promote it. Amongst its members, you also find universities, tertiary educational institutions, and private persons who support the aim of CEP, like academics and researchers in probation from all over Europe. CEP promotes pan-European cooperation in the development and delivery of community sanctions and measures, and its headquarters is situated in Utrecht, the Netherlands. Its Secretary General, Mr. Willem van der Brugge, will hopefully join us towards the end of this webinar for discussion. But let's go back to today's webinar. The topic, as mentioned, is management of sexual offenders. Managing the reintegration of persons convicted of a sexual offense in the community is challenging for probation professionals, prison staff, as well as restorative justice experts. Reintegration of so-called sex offenders in the community still can cause a lot of commotion, and professionals have to deal with this from day to day. However, in recent years, valuable research has been done on effective management and treatment. Nowadays, we know much more on what works. Specific programs such as circles of support and accountability have been developed and successfully implemented. And even recently, recommendations have been adopted at European level regarding the assessment, management, and reintegration of persons accused or convicted of a sexual offense. This document shows that being better prepared to respond to sexual violence in prison and probation should serve to improve the reintegration of sexual offenders into community and eventually reduce victimization rates. Equal attention should also be paid to victims and tailor the support offered by the justice system to their needs as a means to address their harm. While restorative justice is not widely offered in this case yet or applied, it shows positive effects in the offender reintegration as well as in the victim's healing process. Still, restorative justice has to be delivered, taking into account the specific harm caused in this case. With this webinar, we want to present the state of play regarding management and reintegration in the community of persons convicted of sexual offense. All three speakers are leading academics, researchers, and experts in Europe and beyond. This is enough from me now, and Gustav will introduce our speakers and lead you into the program. Thank you.
Thank you so much, Mirka, for this introduction. So let's get to the program. We have 3 presentations that's going to be delivered by 3 distinguished speakers. First out is Kieran McCartan, and he will introduce us to the latest Council of Europe standards that they're working on regarding the management of sex offenders. Secondly, Kasia Utsieblo, working in Belgium and Netherlands, and she will present on the risk assessment and offender management in Dutch and Flemish practice. And finally, our colleague from UK, Linda Millington, she will present on restorative justice and how that can be used in transformation and in cases of sexual violence. So those are the 3 presenters. I will introduce you a bit more in detail later on, but first, I would like to introduce Kieran McCartan a bit more in detail. He's a professor at the University of the West of England in Bristol. He has a long experience of research in the field of criminology and sexual offending. He's currently one of the experts developing the Council of Europe recommendations of assessment and management of sex offenders. And with these words, I would like to give you the floor, Kieran, and the rest of the 20 minutes are yours. Welcome.
Thank you, Gustav. Let me just sort out my screen. Okay, share screen. Thank you, and thank you for that introduction. So the recommendations were published, I would say, about 5 to 6 weeks ago and are available on the Council of Europe website, and they were developed and led by the PCCP. And what I'm going to talk about today is why it was felt that these were needed, why it was felt that these were useful and required, a little bit of the process that went into them, and I'll give you an overview of the recommendations. And I'm very pleased to be talking about these today, but also in the context of restorative justice, because restorative justice was something we paid particular attention to when we were developing the recommendations, and we talked with restorative justice colleagues, including Dr. Ian Martyr from Maynooth University in Ireland, who has done quite a lot of work around this. And when we think about restorative justice and we think about restoration, in part we're thinking about how we reconnect and how we discuss and put things back together again. But what I would argue is that in this process, we're not returning or restoring to the way that it was. We're using restoration to help us move forward in a new way. I often will talk about integration back into the community, and people will say, why do you not talk about reintegration? And I argue that the lack of integration is why people offended in the first instance, and we're not in the business of returning them back to those problematic lifestyles. We're in the business of integrating them and supporting them and restoring them for the first time so that they are functioning, able members of society. So I will now progress to the slides. So the context of this was that the Council of Europe had initially looked at trying to do these recommendations approximately 15 years ago. And they got together a group of experts to talk through and to consider it. But the problem was they spent so much time discussing the context and the definitions. So what is sexual abuse? What is child sexual abuse? Even back then, the context and the discussions around emerging ideas about online sexualized behavior and child sexual abuse online. And they quickly realized that they couldn't get to agreement because not only was there many different definitions across countries, also within countries and across professions within countries. And the conversation and the dialogue reached a roadblock, and it really couldn't continue anymore. So they decided to park it to one side and leave it be. But as the years went by, sexual abuse and sexual violence continued to grow in prevalence and in nature. And one of the challenges that we have in this arena is we actually don't know how much sexual abuse there is, with prevalence studies maybe indicating that between 1 in 3 and 1 in 4 people are impacted by sexual violence at some point in their lives. Now, when you look at it in that way, it becomes less of a criminal justice issue and more of a public health issue and more of a health and well-being issue, because 1 in 3 people is equivalent to cancer. But we don't talk about sexual abuse in the way that we talk about cancer, and we don't support people who are recovering from sexual abuse, either in terms of victims or in terms of people who have committed the abuse themselves, in the same way that we respond and treat cancer victims. So what we have seen is an increase in traditional reporting, an increase in the visibility of offences. It's debatable whether there's an increase in trust in the system. Certainly in the UK, I would have said maybe up until about a year ago, there would have been, but a number of things have happened recently revolving around the place in the criminal justice system that has shaken that trust. And so I think there's a growing realization that you need to report, but people are often not sure of whether they should report. High profile cases, and we are in an era of more punitive governments, and we are seeing more punitive responses. So inconsistency. So what we decided to do is we had a bit of a look, and I was initially invited to Strasbourg to talk about this. And when I started to do some preparation for my initial presentation, I had a look across Europe and what some of the issues were and were not. And interestingly, just before that, myself and Kasia had done a piece of work with a colleague of ours, Vinike, looking at prevention attitudes and measures across across various different countries. And what we had started to see was that there was a lot of inconsistencies in the way that sexual abuse was talked about, the way that it was treated, the way that staff operated in those areas. And we have an updated version of that that has been led by the CEP that will be published later next year. So what we realized is that there were inconsistencies in terms of arrest and prosecution, in terms of risk assessment of individuals, and Kasia will talk in more detail about that as we move forward. Incarceration, even down to the length of sentence, even down to the whether someone went to prison or not, or whether, as we found in the UK, it meets the threshold to go to the Crown Prosecution Service. What treatment looks like, if there was treatment, because we saw in some countries treatment was an emerging idea, where in other countries it was a very solidly stable piece of practice. Community management, again, varied from country to country. And some countries had registration, so sex offenders registers, some did not. And those that did have them used them in very different ways, and sort of posing the question of what is the purpose and function of a register. And data sharing within and between countries, because we had realized that this had been a problem because Hazel Kempshaw and colleagues had done some work on this, on the movement of people convicted of a sexual offence across the Slangdon area, maybe about 7 or 8 years ago. And it became very obvious that there were challenges around management when people lived in one country in the Slangdon area, then worked in another country, or holidayed in another country. This coupled with some emerging issues and debates, so the increased conversation about the prevention of sexual abuse and the idea that you can prevent and you can intervene to stop someone from committing a sexual offence. Increasing focus on life course perspectives, so conversations around adverse childhood experiences and the role of trauma in the life of people who go on to commit sexual offences, and what relationship that has, and whether that's causal or correlational. alternatives. So we've already mentioned things like circles of support and accountability, issues like restorative justice. And as was pointed out, in many ways, restorative justice can be seen as divisive in the academic and practice community when it comes to sexual offending, because you often hear that it reinforces offending behaviors, you hear that it re-victimizes people, but you also see some really good pieces of restorative justice work, like some of the work that's being carried out in Ireland at the minute, or even in America, the work of Elisa Ackerman, where she talks about vicarious restorative justice. So there are places where restorative justice does work in this arena. What are victim issues and needs, and does the system reflect what victims want? Or are victims given and being told this is the response that you should expect? We did a piece of work in Australia that looked at this, with victims often feeling seen and not heard and undervalued. The challenge of things like the service user voice. So within the prison system, we are hearing more and more calls to be service user led. We're hearing more and more calls to be service user informed. But what does that mean when you have got a high risk service user, when you've got challenging and complex offending behavior that will really push the idea of service user engagement to another level? The continued rise of desistance and how this feeds into treatment and management of people, as well as how we measure success. And one of the challenges is we often measure success in treatment as whether or not someone commits another offense, where actually we should be measuring whether or not someone's behavior changes. And that's a really challenging concept about how do you manage success and the treatment and rehabilitation and integration of people back into the community. And to emerging issues around staff training and support. So who was behind the development of the recommendations? Well, they were led by myself, Marianne Flukelstad from Denmark, and Harvey Slade from the UK. The recommendations were drafted for the Council of Europe by members of the Council for Penological Cooperation, whose names you can see there. And we also had a number of contributors. So we had colleagues from the European Court of Human Rights, the Committee for the Prevention of Torture, the European Union, United Nations, Confederation of European Probation, EuroPris, the European Forum that we're speaking at today, the International Association for the Treatment of Sexual Offenders, which is based in and around Germany, and the National Organization for the Treatment of Abuse, which is UK and Ireland, CREVAS, which is based in France, the NLATSA, which is based in the Netherlands and Belgium, and the Association for the Treatment of Sexual Abuse, which is global, but based in the US and Canada. And all of these individuals and groups fed into the process. And I feel that we had a very inclusive, rounded dialogue, and contributions were received and acted upon. So I feel that we got a set of documentation that really reflects what people think about this. So what I'm going to do now is I'm just going to talk through the 10 basic principles underlying the recommendations, and then I'll give a slight overview of what some of the main recommendations are and talk a little bit to them. So the first one is the prison services and probation agencies should manage and seek to reintegrate persons accused or convicted of a sexual offence in line with the risks that they pose. So basically what this was getting at was the fact that they had committed a sexual offence shouldn't count against them in terms of risk management. They should be viewed as low risk, medium risk, or high risk, and their risk of reoffending should be viewed in the context of them as an individual, not based upon the type of offence that they've committed. So it should be no different whether they were convicted of a sexual offence or whether they were convicted of a violent offence. And what we sometimes see, certainly in the arena of public opinion, is that people who have been convicted of a sexual offence get treated differently, and there's often differing views and perspectives on them. Positive steps should be taken to meet the distinctive needs of persons, including their separate accommodation while in prison where deemed necessary, and special management while in custody and in the community. So although at first glance this may seem contradictory to the first basic principles, really what we're saying here is that we should take into account what they need, and if we think for their own safety, they should be kept separately within the prison, or they should be treated separately or located separately as individuals, and we should think about what is the rather than have a blanket approach. Preventing and responding to sexual offending is most effective in a multidisciplinary setting. So this is really suggesting that we need a multidisciplinary approach with different groups and team individuals coming together to help us think through and help us plan the effective integration back into the community of these individuals. Offending behaviour should be considered in a comprehensive manner, which takes in a range of behaviours. So a biopsychosocial approach that considers not only the offending behaviour, but their health and their well-being, which is a nod towards a service user led or service user included approach, which is a nod towards trauma-informed care and developmental criminology and developmental psychology, and the idea that we have to think about how a person got to a point where they committed these offences so that we can better understand how to put in place mechanisms to stop them from committing future offences and live a risk-free, reduced risk lifestyle in the community. Interventions and treatment should be evidence-based and proportional, which is really, really important. So the evidence-based, and this encourages research, this encourages inclusion of research, not only into staff training and staff development, but also into the way that we frame our practices and policies around this. And a good example of that is the debate around high, medium, and low risk, and whether low risk people should get any interventions or whether they should not, because the research shows that they should not, that quite often interventions around sexual offending with low risk people can go on to make them worse. So it's about looking at the evidence and considering what is being discussed. Facilitating the cooperation of persons accused or convicted of a sexual offence. And this really comes from a public health perspective and a service user engagement perspective. However, this is not always the case, especially in prison and especially on probation, where people have court-ordered sentences and mandated treatment programs. But it's about how we engage with people to make them feel that they should be doing this and that we are supporting them on their journey through this, so that they are not simply feeling that they're being done to, but that they're engaging and participating in this program with other individuals. Individually tailored sentence plans should be agreed and should continue and should be regularly updated. And this is really important when we think about how people move from prison to the community and how we sustain and develop risk management in an effective way that helps people manage their risk. Agencies managing people accused or convicted of a sexual offence should work with local communities. So sexual offending and sexual abuse are community issues, but we tend to think about them as individual issues. So we think about individuals who perpetrate sexual abuse and individuals who are victims of sexual abuse. And then on the other side, we try to build society-wide concepts around it. But when we start to take a place-based regional approach, when we start to think about the communities in which sexual abuse happens, we can be more effective at messaging, more effective at prevention, and more effective at reintegration. And international cooperation should be facilitated where appropriate, with appropriate data sharing agreements that allow effective risk management to happen. So going back to an earlier comment about the Schengen area, so that actually, how do you manage individuals who live in one Schengen country and work in another Schengen country, and how do you support criminal justice and community-oriented staff to be able to manage that risk and be able to support reintegration or integration in the most effective way. So they were the basic principles that underline the recommendation. So a real focus on service user cooperation, a real focus on trauma-informed and developmental approaches, a real focus on health and well-being, as well as criminal justice, and a balancing of punishment and rehabilitation so that we actually have a rounded, more fit-for-purpose system. The recommendations then went on to talk about a number of things, including risk assessment. So the fact that people should be risk assessed and this should be part of the life of their sentence, that structured and approved risk assessment tools should be used to inform practice. Management and interventions in prisons around what prisons should offer and the way that it should offer it to people, and the same within probation. Data collection and information sharing was conversations and guidance around GDPR and data sharing. Victims and community support is sort of focused around what victims should be told, how they should be told it, the role that victims should play in the life and the narrative of the criminal justice approach, and also within this restorative justice and a recommendation that restorative justice should be thought about as a proactive, sensible way to respond to sexual offending, but that it should be done in a victim-led manner where individuals are able to opt in or opt out, and there has to be real opportunities for dialogue and engagement around that. Importance of staff selection and training, because what we discovered throughout this is staff selection and training can be anything from a 2-week course to a 3-year degree. And actually, we want to be able to say to staff that if you're working with this sometimes challenging and difficult group, that actually you are trained and you are supported in a way that's fit for purpose. That there should be a clear communication strategy around this, especially around high-risk offenders, with it being released back into the community, with some clear advice and guidance on who should be having that story and telling that story, and good examples of ways of engaging with that. So one good example came from Spain, where they gave the example of when high-risk, high-need people are released back into the community. They sit down and they talk with the local media and they help them craft the story so that they get the best and most up-to-date advice that they can possibly get. And this lastly, we talked about the importance of research and evaluation and development. So about developing the evidence base, about making sure that new and innovative ways of working were captured and evaluated at point of induction. And the idea that actually, again, going back to the beginning, that underpinning this piece of work is the importance of the evidence base. So if you look at what we did this time as opposed to what was done 15 years ago, 15 years ago, they got caught up in definitions and they got caught up in legalities. With this, what we did is we thought about the process that a person convicted or accused of a sexual offense goes through, from risk assessment to prison to probation, to release back into the community and to risk management back into the community. And we've thought about the journey and the process rather than get hung up on the terms. So that's the end of my presentation. I'm very happy to take any comments or questions that you may have around it. Thank you.
Thank you so much, Kieran. Let's see. I see that Laura shared the link to the recommendation at the Council of Europe website. It's in the chat if you want to check the recommendation. Are there any need for clarifications with Kieran's otherwise crystal clear presentation so far? Otherwise, we will save the rest of the questions for the Q&A later on. Thank you so much again, Kieran, for a very interesting presentation and a great piece of work. So we proceed to the second speaker of today, and that is Kasia Usieblo. She's a senior researcher at Van der Hoeven Clinic in Utrecht, Netherlands, and she's also an assistant professor at the Free University of Brussels in Belgium. In Kasha's research, she's focusing on prevention of sexual and domestic violence, as well as the use of assessment instruments. And today she will give us a glimpse of the Dutch and Flemish practice, and maybe present some of the challenges in this work and in this work field. With these words, I would like to give the floor to you, Kasha, and I hope you can share your presentations with us.
Thank you, Gustav, for this nice introduction. But I saw that there was a question on Kieran's presentation. I think Moretta, but yeah, I don't dare to to pronounce your last name. But maybe it's easy. Do you want to ask your question now or later?
Thank you. Quickly, if I read the principles, co-standards in the right way, was it recommended that the offenders are put separately?
No, it's recommended that you should tailor what you need to do to the needs of the offender. So in some instances, like in the UK, for instance, all people convicted of a sexual offence are generally kept on a separate wing in the prison. And there's debate about whether that's useful or whether that's not. But in other countries, they're in with the general population. So really what the recommendation is getting at is that you need to be able to support and work with the people in the best possible way that you can do. And that's to say, is actually putting them in seclusion the best way of managing that? Because the reality is when they come out of prison, they won't be in seclusion anymore. So yeah, it's more to say, what is the best way of managing that? And really to call people to think that, is seclusion the best mechanism or is it not?
Thank you for clarification. Actually, we have the same in Georgia. We put them separately, absolutely, which excludes them of being interactive with other prisoners, and that's not the good thing. Yeah, thank you. And thank you, Kasha, for
You're welcome. You're welcome. Okay, so I'm going to start sharing my presentation. No, this is not working, sorry. Okay, do you see my slides? Yes,
yes, we do.
Do you see it?
Yes.
Without the notes, right?
No notes.
Okay, thank you. Good afternoon, everybody. Thank you again for inviting me to this interesting event. As mentioned before in the nice introduction, I'm a senior researcher at the Forensic Hospital in the Netherlands. And I also conduct assessments, mainly risk assessments in our forensic patients. And in addition, I also perform assessments for court in Belgium. And I was involved in the development of the new guidelines regarding sexual violence, including guidelines regarding risk assessment by the High Council of Justice in Belgium. So that's why I would like to focus on risk assessment and risk management, two important issues included in the recommendations, as Kieran described. And more specifically, I would like to talk about the problems we encounter in practice that I think we need to know how to counter them if we want to implement these guidelines successfully. So I will illustrate some problems with examples from Belgium and the Netherlands, but from what I can see, these problems are universal in nature and will probably be encountered in different countries. But first of all, I would like to briefly discuss the state of play with regard to the implementation of risk assessment in Belgium and the Netherlands. As we see in other countries, our work as practitioners and researchers helps a little bit to shift policy regarding people who are convicted of sexual offenses. But although we would like to see it otherwise, it is often mainly because of high-profile cases that substantial changes in policy are being made, also with regard to risk assessment and management. And unfortunately, we had a few of those in Belgium and the Netherlands as well. And one of our most well-known Belgian high-profile cases is the one of Marc Dutroux. Some of you might remember this case, who, together with a few accomplices, including his wife, was arrested in 1996 for the abduction, torture, and rape of 6 girls, of whom 4 had died. One of the most important policies that have been installed after the truth is the so-called cooperation agreement, as you can see here on the timeline. And the basic assumption of this agreement is that supervision and or treatment are obligated for sex offenders who want to make use of any early release modality. But the agreement also allocated more resources to outpatient centers specialized in the treatment of sex offenders, as well as to the installation of professional teams in Belgian prisons specialized in the treatment and assessment of sex offenders. In 2017, the Dutch case of Michael P., who raped and killed a young girl during his leave from a forensic center, where he was actually detained and treated for previous sex offenses, caused social unrest in the Netherlands. This case has highlighted the need to carry out risk assessments during detention as well, and the need to allocate high-risk profiles to forensic inpatient centers. And the third, more recent Belgian high-profile case is the case of Bakelmans. In 2019, he was accused of the rape and murder of a young girl. His case has yet to go to court. Actually, it's all happening, or the court sessions are starting next week. But it has already facilitated the implementation of risk assessment in the Flemish probation services and has led to the development of new guidelines regarding sex offense cases, including the recommendation to conduct risk assessment on a regular basis. So where are we now with regard to the implementation of risk assessment? As said, the last few years, risk assessment is being increasingly administered in people who have committed violent crimes, and especially actually in people who have committed sexual violent crimes. But despite this increased attention, it's not yet fully implemented on all levels across all settings, neither in Belgium nor in the Netherlands. We unfortunately don't have the time to go in much detail, so I described all the details or a global overview of the implementation across settings on this figure. And if you have specific questions, you can ask them afterwards, of course. But I'm going to focus on general tendencies. And what we see in Belgium is that only the prison services are obligated by the law to conduct structured risk assessments in sex offenders. In the near future, though, the Flemish probation services will also be probably be obligated to conduct structured risk assessments. And I heard a couple of weeks ago that in the first phase of that implementation plan, the focus will lie on sex offenders. And although we observe a push to apply proper risk assessment tools in other settings as well, as you can see here, described on the figure, there is no structured approach yet across settings and centers. And although in Belgium we always look up to the Netherlands, also with regard to risk assessment, we have to conclude that despite the fact that risk assessment tools have been embedded in the system there for a longer time than in Belgium, they are still not compulsory in many settings, in many centers. And hence I hear from a lot of colleagues that they are not always used yet. So, but having said that, the use of these tools is increasingly strongly recommended, and the rules in this respect are becoming stricter as the years go by. And I heard that there will be new guidelines starting of 2022 regarding the use of risk assessment also in outpatient and inpatient centers. So the rules are getting stricter and stricter. So this indicates that although we have taken important steps in recent years, there is still room for improvement regarding the use of risk assessment tools. But there are other problems that unfortunately are not often discussed in practice nor in research. Because most scientific studies focus on the question which instrument exhibits the best predictive validity, as you can see here, or deduct from the titles I'm showing you here. There is also an ongoing debate on whether actuarial tools that work with numbers and norm groups lead to more valid predictions than structured clinical judgment tools that do not rely on norms or numbers, but rather on the final judgment of the clinician. But the recommendations of the Council of Europe, they do not really take a stand in that debate, but mainly stress the importance of using validated tools. And that's, of course, a very important issue to emphasize. So I agree with that. Whether the risk assessment tools exhibit adequate predictive validity is indeed an important issue, but because of that focus, we have neglected other prominent issues with risk assessment. And that is why I would like to highlight 3 issues that may hinder an adequate implementation of risk assessment tools in practice. A first issue that I would like to raise is, do we fully understand the purpose of risk assessment? When I give this lecture or a general lecture on risk assessment to lawyers or judges or other professionals that are not trained in risk assessment, including probation officers or clinicians, it is clear that they do not fully understand its purpose. Many are convinced that the only aim of risk assessment is prediction, is pure prediction, and that the main question to be answered with a risk assessment tool is this person going to commit new offenses or not? And just to be clear, this is not really a question that a risk assessment will help us to answer, but that's another issue. But as described in the recommendations, as you can see here, this is not the main purpose of risk assessment. The risk assessment should guide our prevention initiatives, and the main question is therefore, how can we lower that risk in that specific person? I also see that many practitioners want to avoid risk assessment because of that wrong assumption. They do not see how they can use it in their everyday work, or they are afraid that the risk assessment will be used in the wrong purpose. And sometimes I have to agree, because indeed we see that there are politicians, policymakers, and even judges and other practitioners that openly state that a high risk profile, for instance, should be locked up for a long time, preferably forever. So an important issue that I want to raise is, how can we make sure that risk assessment is embedded in our system in an appropriate way that aligns the true aim of risk assessment? That is, to inform appropriate decision-making and actions with the aim of reducing risk. As you can see here, a citation from Kieran and colleagues. And before I want to raise my second issue, I have a question that I would like to pose you. And I'm going to describe 2 situations, and we're going to read them together. And then my question to you is, which of the following situations demonstrates a higher risk relative to each other, of course? So the first situation is, Mr. Peters obtains a score of 1 on a static 99R. With this score, he falls into the low risk category. So that's the first situation. And the second situation is, when comparing Mr. Peters' static 99R score, for those who don't know the static 99, that's a specific risk assessment tool for sexual recidivism. And when comparing Mr. Peters' score on this tool with the norm group, we conclude that 5 to 9% of the norm group were reconvicted with within a 5 to 10 year follow-up period. So think for a second, and maybe you can post it in chat. I'm curious which of the situations describes, according to you, a relatively higher risk situation. I don't know, Gustav, can you check? First one or the second one?
Yes, we have some reactions from Moretta. She says the second one.
Okay. Thank you very much, Moretta.
I think the voting has begun, so now we get some responses here.
Yeah, people have to think, of course. Yes.
Yeah.
Olga, yes, Olga Kisilio, Bruno Gross, Carla Manti all says 2, number 2.
Mm-hmm.
Again.
Okay, oh, it's coming in. I see the numbers. Sorry, I'm giving you more work. Is the tendency to go to the second situation, right?
Yes, definitely.
Okay. Okay, thank you all for your answer.
Reaction, both are the same.
Okay.
From Nakarpluk.
Okay,
and
thank you.
One first.
Oh, one first. Okay, very interesting. Thank you all for reacting. Well, maybe I think some of you, I heard that some of you have noticed that actually this was a trick question because both conclusions refer to a low risk. And the score of 1 indeed falls within the low risk category. And 5 to 9% of the norm group with a score of 1 was actually reconvicted according to the manual of the Static 99. So my questions to you, and you don't have to answer, just think about it, is why did you get the feeling that one scenario was higher risk than the other? And another question you could pose yourself is that a problem? I'll try to answer a few of the, at least I hope one of these two questions. So this brings me to the second issue that I would like to address is, do we fully understand the risk assessment outcomes? And the first more general finding is that we tend to overestimate the risk of reoffending in sex offenders. To illustrate, a study was conducted in Dutch probation officers and judges, among others, and other groups, as you can see here. Sorry, I didn't find an English version of the figure. I'm going to tell you what is described in the figure. So no worries. The researchers asked the participants to indicate an expected recidivism rate in low, moderate, and high risk profiles. And the colored horizontal lines, as you can see on the figure, indicate the true recidivism rates of these three groups. The columns indicate the percentages or the estimations that were given by the participants. And just, you don't have to look for details, but I hope you see the global tendency here is that all participant groups tended to overestimate the risk of recidivism for all three risk groups. And this is an example from a Dutch study, but we see that in other studies, other international studies as well. Second, the format in which the risk assessment outcomes are communicated affects what is actually heard, as you have experienced just a minute ago. Research clearly shows that when risk is described as a categorical description of risk, meaning in terms of, for instance, low, moderate, and high risk, people tend to overestimate the likelihood of sexual violence more often than when numbers are being provided. And it's interesting to see that we saw I think I understood it correctly, that we saw the opposite, right? The opposite in your answers. So you may think, well, let's not use the categorical descriptions then. Well, that may be not the solution, because we see that people have a difficult time understanding numbers and numerical outcomes from risk assessments as well. Hence, we should explore how we can increase the understanding of risk assessment outcomes. But to make things more complicated, our understanding of risk is not only influenced by the way we describe risk, but also by many other factors. And although research on this topic is relatively limited, studies should suggest that offense characteristics and the characteristics of the offender and of the decision maker may all influence our understanding of risk. And to illustrate, so for instance, when a serious and gruesome crime is committed, the assessor and the decision maker are more often influenced by the horror of the offense and tend to overrule the risk assessment outcome. And this, despite the fact that we know that the seriousness of the offense is not a good predictor of sexual recidivism. So that's a problem. Another example, there are some studies that suggest that jurors take the information from a risk assessment less into account when the defendant shows little remorse or has already a history of previous sexual offenses. So that might also be a problem in practice. And finally, the characteristics of the recipient, and in our case, this is often the decision maker, for instance, a judge, they are also of importance. For instance, if the recipient has a difficult time understanding numbers, he or she tends to ignore numerical risk assessment outcomes more often. So people often do not like to see numbers. They have a difficult time understanding them. So why is it important to know which factors influence our understanding of risk assessment outcomes? Well, we should realize that the way we communicate about the risk assessment outcomes, as well as our understanding of these outcomes, have an important influence on the decisions that, for instance, judges make or that you make in practice. Which is no surprise, given that risk communication functions as one of the most important links between risk assessment and risk management. Differently put, if the communication is incorrectly executed or is unclear, and or the decision maker doesn't understand the risk assessment outcome properly, it influences the decision-making process and hence may lead to inadequate risk management strategies. And then the final issue I want to raise is whether we know how to match risk assessment with risk management with risk assessment. As mentioned in the guidelines, and as you can see, and also as shown in various studies, there has to be a clear link between risk assessment and risk management. And Kieran already mentioned a few of these general guidelines about matching these two. Sorry, there is a micro. Okay, thank you. A risk assessment has to inform our risk management policies regarding the intensity of the management plan and the content of this plan. For instance, the intensity of the risk management program should align with the risk assessment outcomes. This is also called the risk principle, and Kieran already mentioned it in his presentation. This means that for low risk profiles, supervision is often sufficient. Moderate risk profiles should ideally receive forensic outpatient treatment, whereas high risk profiles should obtain intensive long-term inpatient treatment. However, that's theory. Does that also happen in practice? That's the next question, of course. And the problem is that practice clearly shows that it's not obvious to follow that risk principle. Dutch research shows, for instance, that the advice assessors for court give regarding treatment is not always in line with risk assessment outcomes. And in that study that I'm referring to on the slide, they even found that in some high-risk cases, even no treatment advice was given at all. Another Dutch study from my dear colleague Winneke Smit, who's also my boss, so I have to mention her, of course. She found that the allocation to treatment centers is also not always in line with risk assessment outcomes. For instance, the table shows that high-risk profiles still end up in outpatient centers instead of inpatient centers. And I work in an inpatient high security center, and we also encounter low risk profiles, for instance, in our clinic, and we sometimes do not know what to do with them because they don't need long intensive treatment. So that's a problem. We see also a similar problem in other settings. For instance, Dutch probation officers seem to not always take into regard that risk principle. And various officers do not always focus on the risk factors that are related to recidivism in their clients as identified through the risk assessment. So how did that happen? How can we explain these findings and these problems? Well, one explanation for these findings may be that practitioners do not fully understand risk assessment outcomes and or do not know how to align risk assessment outcomes with their risk assessment strategies. At least that is what we found in our recent Dutch study in the Netherlands. And we, sorry. Yeah, we asked practitioners from outpatient and inpatient centers how they translate their risk assessment into their clinical practice. And our participants indeed indicated that they didn't always know how to understand the risk assessment outcomes, and that they didn't have the theoretical nor practical tools to translate risk assessment outcomes in adequate risk management strategies. Consequently, they acknowledged that the risk assessment outcome was often omitted along the way, which is, of course, not really the purpose of risk assessment. So to conclude, we, of course, urge people to apply the recommendations, all the recommendations that Kieran has described before, but also the recommendations regarding risk assessment and risk management, because research clearly shows that if you do that properly, recidivism rates in sex offenders and other offenders can be lowered. However, when implementing these guidelines into practice, I think it is of crucial importance that we realize that implementation involves much more than just using the tools, because it raises many more questions that we need to dwell on, and preferably before we implement it. I highlighted 3 issues that show how complex implementing these guidelines is, which led me to the following 3 questions. Do we fully understand the purpose of risk assessment? Do we fully understand the risk assessment outcomes, and how should we communicate about these outcomes in order to improve that understanding? And finally, how can we ensure that risk assessments lead to adequate risk management strategies in practice? I really hope you were not expecting to obtain all the answers during this presentation, because the truth is that there is no univocal answer to these questions yet. And much more needs to be explored and investigated in research and practice. But I hope that by sharing thoughts, ideas, experiences with these issues, we will be able to help each other through this process of improving our practices with people who have committed sexual offenses. So this was it. Thank you for listening. Those who want to read more about these issues and other interesting topics related to sexual violence may be interested in our upcoming book. This should be out by the end of this week. It was edited together with Kieran. It's a little bit of self-promotion. Apologies for that. Or some of you may also be interested in these articles that describe the Dutch and Flemish situation in more detail. So thank you for listening.
Thank you so much, Kasia, for this very interesting and clarifying presentation. We have a few questions in the chat, and I think we will save it for the discussion, for the Q&A. It's mainly about risk assessment tools being used for classification, but not for treatment planning, and that's highly relevant as well mentioned in your presentation. But we'll save that for later. Very important issue.
Looking forward to
it. I would also like to say welcome to our newly arrived participants. The webinar started at 2:00 CET, but I hope you can enjoy the last hour of the webinar anyway. So we have one presentation left, and that is Linda Millington. She's going to present on restorative justice and the transformative power of restorative justice and the usefulness to sexual offense cases. Linda is Deputy Director at the charity Why Me, which is promoting greater access to restorative justice measures in England and Wales. Linda is a trained restorative practitioner, and she has been specializing in cases of sexual and domestic abuse. So with these words, I would like to leave the floor to you, Linda.
Thank you, Gustav, and thank you for letting me speak here today. I'll just share my screen so we can get the presentation up. I'm as well as a restorative practitioner and the work I do at Why Me, I'm also a member of the European Forum on Restorative Justice's working group on gender-based violence, and particularly the work stream looking at sexual offences and restorative justice. as we said, Why Me? We are a national charity in England and Wales, and we do a lot of work to promote access to restorative justice when everyone's been affected by a crime or conflict. And we're particularly interested in widening the use of restorative justice into areas where traditionally restorative justice has not been used. So we're very much about pushing the barriers, and that includes, for example, hate crime, domestic abuse, and sexual abuse. We do a lot of work to lobby our government over here on the use of restorative justice to make sure that it's included in legislation here. We also run our own restorative justice service. We carry out restorative justice interventions, and particularly we do this when other restorative justice services are in England and Wales are unable for one reason or another to take such cases. And that might be for a variety of reasons. That might be down to facilitator expertise, or that might be down to what the particular funding criteria is in the local area, as there's still not all restorative services are funded to take cases of sexual abuse. We were actually formed as a result of a crime. One of our founders, Will Riley, was a North London businessman, and he was burgled and assaulted by Peter Wolf. Peter was in and out of prison all of his life. He was a drug addict, he abused alcohol, and he met Will in a London prison. And when Will explained the impact of what had happened on him and his family, Peter actually made the decision to change his life, and has never committed a crime since. Will set up Why Me over 10 years ago now, because at the time in England there was very little known about restorative justice, and the purpose of Why Me was to campaign to show its positive effects. Will and Peter are still friends today. Peter now lives in Sweden. He's an academic. He speaks very eloquently now about restorative justice in his experience. So what I'm going to talk about today is a little bit about restorative justice, and apologies to the people in the room who probably know more than restorative justice than I do. We're going to hear from some of the voice of the survivors who've taken part in the process, and then a quick look at some of the barriers and some of the concerns. So what is restorative justice? Well, very simply, in a criminal justice context, it's about repairing harm when offence has taken place. And really, it's about putting victims at the heart of the process. And when I mean victims, often I flip between using the word survivor, victims, or harmed person. We tend to use in this arena a lot of the term survivors. It's about facilitating a structured dialogue in a carefully controlled and safe way. For the survivor, it really is a way to express how the crime has affected them, and to get answers to their questions. Why me? Did you target me? Did you follow me? It's also, sometimes not so much in sexual abuse, but it might be that the harmed the survivor wants to get answers about what happened. They might want to fill in some of the gaps about the facts of what happened. Why me is the number one question most survivors ask. No surprises then why our organisation is called Why Me. For the perpetrators or the harmers, it really is an opportunity to take a look at themselves and take a look to see and understand how their actions have affected others, whether that is the direct survivor or their families or other people around them, which we call the ripple effect. It is a chance to apologize. It might be a chance to make amends and not do the same thing again. one of the misconceptions about restorative justice is that the survivors have to forgive the perpetrators before or during the restorative justice process. That's a misconception. Yes, it does happen, and many survivors will forgive their perpetrators, but also at the same time that's part of their healing, because it's about forgiving themselves as well. But that is not an essential part to a restorative process happening. So what is restorative justice's key features? Well, firstly, it's voluntary for both parties to take part, and parties can withdraw at any time with no questions asked. We as facilitators don't go and say, well, you don't want to do this, why do you do that? Why do you not want to take part? They have to want to do that. They want to have to do restorative justice. And it's not a one-size-fits-all. All of the cases that I've facilitated in both domestic abuse and sexual abuse have worked very, very differently. So we do have a model, but actually we have to throw that model away and work very much on what other participants want from the process and how they want to work it. It's managed by trained facilitators like myself, who have undergone a lot of training, not only just our basic restorative justice training. We recommend that specialist training to carry out restorative justice in sexual abuse cases is also carried out, is also undertaken. The way we work is we work on a model of questions that we use to help structure when we first meet people, when we're preparing them for a restorative meeting, and also then when a restorative meeting actually happens. And they're based on the questions of what happened, what did you think and feel at the time, what do you think and feel now, what's been the hardest thing, and what do you need to repair the harm, what needs to happen to make things better. There are several ways that restorative justice can happen. If you Google restorative justice, you will probably get up lots and lots of hits on the face-to-face meeting. And yes, the face-to-face meeting it produces the most impact. But what if it's not safe? What if the participants don't want to meet face-to-face for one reason or another? Well, we can still work. We can still work. So we can do things like letters exchange. We can work by passing information between the participants. We can ask the survivors questions of the perpetrator and bring their answers back to them. But for a lot of people, actually just having a conversation with the facilitators, what we call a restorative conversation, is actually very beneficial in themselves. And it might lead a survivor to actually say, I've processed what's happened through this process. I don't need to meet the perpetrator anymore. So does restorative justice work? Well, research that was carried out in England and Wales around about 2006, 2007 shows that it reduces repeat offending by 14%. Now, I will say hands up that is not looking at serious crimes like sexual abuse. That was a randomized trial that would take place. There is a strong argument that restorative justice may encourage victim empathy in offenders, particularly when they're faced with the consequences of their actions. But personally, I feel there is a need for more research in this area. Okay. I always feel a bit, I'm going to say some of the words of survivors who've been through restorative justice, and they are ambassadors for Why Me. They talk about their experience, they talk about the power, and they also talk about the transformative effect of it. They say it far more eloquently than I could ever say. So I hope you will forgive me if I actually quote their words as we go through this part of the presentation. So Rosalind was repeatedly raped and tortured in her home by a serial rapist. Her 2-year-old daughter was sleeping next door, but was not disturbed. He was caught, convicted, and received 3 life sentences. But Rosalind felt very strongly that she wanted to ask him why. Really important question for her. And Rosalind had to fight to get restorative justice. She was told no repeatedly. And she's quite a tenacious person, but she knew what she wanted, even if she didn't know it was called restorative justice. And 14 years after the crime happened, she was sitting in a room in a prison, face to face with the person who was responsible for her rape. And I hope you don't mind if I talk through what Rosalind says. She says, "When he was led in the room, I found myself transfixed. I didn't recognize the man sitting opposite me as the monster who had attacked me. He looked nervous, sad, and weak. I'd carried an image of him in my mind for 14 years, and he wasn't the same man. There were 7 people, my friend, facilitators, prison officers present, and he was asked to give his version of events leading up to the attack. He took a long time to speak. He couldn't look me in the eye. But as he described the moment he first saw me, he finally looked at me. He said he was a monster that night. He enjoyed violence and got a kick out of it. He apologized, and he had years of therapy in prison, but didn't realize until the actual day of that meeting the harm that he'd caused." And then Rosalind reflections after the meeting, and she says, "The meeting gave me a chance to voice the harm caused, not just to me, but everyone else that was involved. And I wanted to see for myself if I was going to be at further risk. Since the meeting, life's been better. I generally feel lighter, less afraid, and happier. I realized that the attack was about power and control. Now I've regained my sense of personal power and control." And in another example, Wendy was sexually abused by her father when she was 14. He pleaded guilty, and at the time received a small fine and a 1-year conditional discharge. It was 40 years later before Wendy was able to meet her father in a restorative meeting. And what was really important for Wendy is that she wanted proof that the abuse had existed. At the time, she was taken away from the home. She was placed with her aunt. She didn't really understand why. And her father had always denied that the abuse had taken place. So she ended up blaming herself. She thought that she'd done something wrong. She'd always wanted an apology. But again, every time Wendy, who again didn't really know what restorative justice was, she was trying to get her answers. She was blocked. The answer was always going to be no. And actually, it was a chance conversation with a friend who knew about restorative justice that put Wendy in touch. So when Wendy first met the facilitators that facilitated the meeting with her father, she says, "They made it clear to me that there was no guarantee I'd get what I wanted, but they would do all they could to help me. The fact that restorative justice was victim-led made me feel for once I was actually being listened to. They asked me if I would actually like to meet with my father and confront him with the questions I'd always wanted him to answer, as well as receive the apology I'd yearned for." And then again, Wendy describes how she felt after that meeting. And she says, "Amazing. At the time, I don't think it really hit me. I was too absorbed with the meeting itself. Once it had finished, I felt elated. Restorative justice hasn't helped Wendy." Oh, sorry, apologies. "There was a lot going on in my head, but I got the apology and I ran with it. Restorative justice hasn't just helped Wendy. Once the weight had been lifted from me, it helped me so many more around me. My nearest and dearest had suffered alongside me for as many years as I had. Once the darkness had gone from me, it was and still a far brighter day for all of us. And I'd just like to say thank you to Rosalind and Wendy, who've shared their stories with Why Me. Wendy is so passionate. She spoke at a Why Me event last week, and her approach is if she can convince one person of the power of restorative justice by her speaking, then it's worth it. Very briefly, a researcher from the University of Oxford, Diana Batchelor, has done some work into why why survivors find restorative justice and so important, transformational in cases of sexual abuse. It's really important, and I hope that Rosalind and Wendy's stories show this, that it's important for survivors to have their say, to be treated fairly, even if a restorative meeting does not take place. And as I said earlier, even the power comes back with the survivor making the decision for themselves not to take part. Survivors do want to find out more about the offender and the crime, even if the answer might not be the one they were expecting or even the answer that they wanted. Really important, again, is about when survivors have taken part in restorative justice, they see themselves differently. They don't. Wendy is a good example of this. She thought she was to blame because she was taken away from the home, but then taking part in that meeting when she got the apology that she so long wanted for changed how she saw herself. Victims no longer blame themselves for what happened. They're not afraid. They've got their sense of control back. Many survivors, when we're working restorative justice, actually don't want to focus on what happened. They want to focus on the future or any particular future relationship, particularly if the abuse has happened within a family context. They value the input. They value learning from the professionals who are working with the perpetrators to understand what programs that they may have undergone as part of their rehabilitation. But this is a controversial area, and there are a number of potential concerns surrounding doing restorative justice with cases of sexual abuse. Obviously, there's the physical and the potential psychological harm. I think Kieran alluded to it earlier. There is the risks of re-victimization of the survivor. Will the perpetrator use it in some way to exert control again over the survivor? But risk assessment, quite ironically, Case has gone and talked about risk assessment. Risk assessment is from day one, and it's always carried out for restorative justice. We ask ourselves some very, very specialized questions about not just the perpetrator, but also the survivor. What are their attitudes towards the events? We use particularly enhanced risk assessments. There's only one way we describe what we do, and it's preparation, preparation, preparation. We try and think when we're preparing people to take part in restorative justice of all of the different possibilities. There's lots of talking about, well, what if someone cries? What does that mean to you? What does remorse mean to look to you? So there shouldn't be any surprises in any restorative process. We undergo specialist training, and we're also absolutely mindful of the importance of working with all of the specialist agencies that work with survivors and also work with the perpetrators. So we're the experts in restorative justice, but we need the experts of the professionals who work with sexual abuse to be able to inform our practice. So there's lots of, as we've already alluded, there's lots of evidence about how restorative justice is an established response to less serious crimes. and there is less data about its use with sexual abuse. So some people are then naturally concerned about, is it effective? Is restorative justice effective? And I think hopefully the two examples that I've given you today have shown you that absolutely it's effective and life-changing. Our own analysis of general data collected by our government shows that anyone who's experienced a crime is and taken part in restorative justice is likely to report improvements in their health and well-being. They're better able to cope with aspects of their lives. They feel safer and they feel more empowered. There is a lack of similar data, and this colleagues are here today can point me in the right direction, but we have less data on the impact of effectiveness on offenders. There is an argument that restorative justice is very resource intensive. Well, because of the amount of training that facilitators undertake and how long it can take for a restorative justice process to take. It can take years, but then again, it can happen in a very short time scale. I think one case I did about 3 years ago took about 2 months. But it's about the long-term impact on restorative justice and all of those cost savings. It's cost savings to the criminal justice system, cost savings to the health system, less days lost by people ringing in sick at work. It's a sustainable solution to be able to work with crime. And I'm not going to say here and say restorative justice is an alternative to other outcomes from the criminal justice process. Restorative justice is very much works alongside prison sentences, community sentences. And I know you're probably all going to get the slides afterwards, but I've just put some references there for you that you want to pick up, including some research that YME has recently produced. Thank you. So any questions or comments?
Thank you, Linda. Mirka, I think we can move on to the Q&A because we have a few questions in the chat, I imagine.
Yes, actually we can. First, I would like to mention that for those who are interested, Laura and Emanuela, they just put link on the working group of gender-based violence. But to the questions, I will start from the last presentation. We have one from Ranisha da Silva, and it's, since effective empathy and remorse play key roles in restorative justice, what's your experience is like with perpetrators who have restricted effective empathy and remorse, like individuals with high levels of psychopathy traits? And Lucy Coleman, she asked, equally those on the autistic spectrum.
Is that
yes,
for me?
Yes,
on the remorse question and the empathy, that I didn't touch upon that in my presentation, because basic tenet of restorative justice is that perpetrators have to accept responsibility and have to accept remorse. That's not necessarily the case in cases of sexual abuse. We have to have honest conversations with survivors so they're fully aware of what characteristics the perpetrator might be demonstrating, so they can make their own choice if they still want to sit in a room with them. Because for some people it is, and particularly the case that I did about three years ago, and it's over a couple of months, what was important for the survivor was that they could say what they wanted to say. They had exactly what they wanted to say, and that was important for them to do that. They knew particularly that they might not, that the perpetrator might not even say anything, let alone look them in the eye. And there was one case that was talked through when I was training, and it was exactly that. But what was important for the survivor is they wanted to leave the room first, so the perpetrator saw the back of her head, because that was the last thing she saw of him. And that was the really important thing for her. Yeah, on the autistic spectrum, absolutely, and we've just finished a piece of work looking at hate crime with people with learning difficulties and autism, and it's very much about how you adapt the restorative process for their needs. So, very simple thing, you might use pictures instead of words. You might do very short meetings rather than like an hour-long meeting when you're talking to someone. But I absolutely understand about that those feelings of empathy and remorse. It might be more difficult to manage, but it is about being honest. It's about being honest with everybody, so there are no surprises.
Well,
Mirka, please.
we have one more question. Does participating in restorative practices help perpetrators for early release or any kind of perks?
No. Rosalind and another survivor who took part in restorative justice were very concerned 5 years ago with the parole system, that parole boards who make the decisions on whether perpetrators are released or not would see restorative justice in a positive light, and it would lead to reduced sentence, or it would lead to early release. We've done a lot of work with our parole board over the last 5 years, culminating this year when the parole board has made it very, very clear that it's the assessment of risk that is an important factor. It's not the fact that someone has taken part in restorative justice. They're interested, but it's not the determining factor.
Thank you. I see Kieran is raising his hand. Would you like to comment on the last part?
Yeah. Just to reinforce the point, actually, because we see the same thing. There's an expectation if you engage in circles of support, people think, oh, does that mean that you'll be treated differently? Or if you drop out of circles, will you be treated differently? The reality is it doesn't aid you one way or another in those negotiations. It may show a willingness to do something, but it doesn't get you time taken off, doesn't get you time added if you drop out. So yeah, it's really important to say that these are additional things that people can do and engage with, but that it doesn't reflect upon parole board decisions.
Thank you, Kieran.
Mirka?
Oh, actually, we have another questions. One is from Marianne, and it says, what about for the prison environment where the alleged perpetrator and the victim are living in the same establishment? What would be the ideal way of managing this? I guess this is for Linda.
That's a very interesting question. I haven't actually dealt with a case like this. There was a case that was of this nature where we found out by chance that the perpetrator and one of their relations of the harmed of the survivor was potentially going to be in the same prison. And we had to do all of the risk assessment and disclose it to the prison service that was going to happen. Now, restorative processes are used a lot in prisons to be able to address a lot of the harm and the environment within prisons. And it's a way of that some of the impact is that there's less assaults on staff, there's less incidents that happen on the prison wings. In a kind of sexual abuse systems, I would hope that the prison service would have enough information so the two people would not be in the same prison. I don't know if anyone else, Kieran, would want to comment on that one as well.
Yes, so I would hope that they would have that degree of insight as well. then you would not necessarily want them in the same prison. In the same way that, for instance, you know, if people are convicted of engaging in multiple perpetrator offences, you don't want the same group of perpetrators together in the same establishment or on the same wing, because that could cause difficulties. So, okay, but like what I would say is it might be worth looking at some of the work of people like Nicholas Blagden and some of colleagues at Nottingham Trent and the late Ruth Mann, who've done a lot of work around rehabilitative culture in prisons and the way that prisons can be rehabilitative in not only how they set up and run themselves, but the way that they engage with people under their care so that they can get the best rehabilitation, the best treatment, and the best experience from being in the establishment, so they can come out more well adapted.
Thank you. I would like to go back to one of the questions previously posed in the chat, and that was on risk assessment. And I guess this goes to you, Kasia, and maybe Kieran as well. And it's about the risk assessment. And these tools are now widely spread, I would say globally spread around the world, being used in both prison and probation settings. But as mentioned in the chat by a few of the participants, in some countries it's mainly used for classification and not really for risk management or treatment. So how can we sort of promote a move from a strict classification use of these tools to more integrated case management procedure?
So that's the issue that I also pointed out, right? That it's not always used in the right way, or if I would have the answer, that would be great, but I don't, because it's difficult. It depends. So if you use risk assessment for classification, my first question is, what kind of classification, right? Because it would be good to classify some groups, to have the higher risk groups in inpatient centers and to get the others in outpatient centers, or only on the supervision of probation, for instance. So sometimes classification is good, right? But I notice, and that's my experience here in Belgium, that that we try to indicate, to show policymakers that the link between risk assessment and strategies is very important by education. We react on everything they say. So by writing pieces in the paper, by giving lectures to them, and I see that it's difficult work, it's very intensive, but I see that after a couple of years of pushing and stalking them with propositions and papers and so on, it's starting to get effect. And that the last few months, some politicians are really listening, and we are discussing how we can implement that better in our Belgian practice. But yeah, I don't know about another way. Kieran, do you have any tricks and tips?
I suppose to me, it comes down to what the purpose of risk assessment is. And the purpose of risk assessment is to establish A, risk of reoffending, and B, risk of harm. So, you know, if we're saying that risk assessment's about classifying people and putting them into this prison or that prison, or it's about putting them on this treatment program or that treatment program, we need to think it through right through the process. Because if you're saying you're going to go to prison A rather than prison B because you're low, medium, or high, then you may only have certain treatments or interventions open to you because of where you go, and then that could affect whether or not you get released and how you get released and then how you get managed. So it has to be a process. So one of the things that happens within the UK is that risk assessment happens at different stages. It's a continual process, but it's used by a multitude of professionals. So it's used in court, it's used in sentencing, it's used in the prison, it's used in the community by probation. So what we end up seeing is that risk assessment is as much a part of the process and the practice of risk management as it is about the actual designation of risk. So I would always say, you're giving people a tool to use. Why are you giving it to them? If it's simply to classify a risk once, I would question why you're doing that. If it's to be a part of treatment and rehabilitation and management, then it needs to be done multiple times. Because as Kasia, who is infinitely more knowledgeable in this than I am, would be the first to tell you, risk is dynamic. It changes. The risk you pose one day is not the risk you pose the other day. It's a bit like PCR tests, isn't it? You can take a lateral flow test one day, but the next day you might have COVID. So that's why you test constantly.
Yeah, true. And I have some issues with how we apply risk assessment, for instance, in Belgium, or the reaction I get from some people when I teach, when I give classes to, for instance, judges. They say, okay, if it's for high risk, then I tend to give a higher sentence. And I'm like, why is that? Why is that really the purpose of risk assessment? Because actually you're basing your judgment on our prediction of the future, which is not 100% correct all the time. And as Kieran pointed out, risk is dynamic. So I don't see the purpose of that. I don't see the added value of that. So there are questions that we should start posing ourselves, so we can develop a vision around that, because I see that those questions pop up all over the world now, because people are more and more using risk assessment tools. I see more questions.
Yes, we have some reactions, like in Georgian prison, risk assessment is to maintain security prisons, and the other one, the risk assessment and approval to proceed context in whose interest is the intervention being done. It takes some pushing to help prison governors to recognize and value the assumptive priority of victims' interests in RJ. Would like to comment?
Well, on the first one regarding prison risk assessment is to maintain security in prison. I'm curious, what do you mean by that, Moretta? If I may say Moretta, sorry, because yes, I don't dare to say your last name.
Absolutely. Okay. Yeah, well, first of all, risk assessment was not established long ago in Georgian prisons. Therefore, it's quite new, let's say 5 years old or so. And it's not all prisons using it. And we have like 15 prisons in the country. With a lot of inmates, like we are 3.5 million people and up to 11,000 inmates, which is a lot. And we have also a lack of staff. We don't have one prison officer who takes care of one inmate, but rather one person, social worker mainly, taking care of 300 inmates. So with that capacity, you can imagine that the risk assessment to establish it or introduce it in the right way is a problem. But mainly they started classifying people to maintain the security in the prison. So they put high-risk prisoners together, low-risk prisoners together to diminish the risk of conflicts in the prison and to maintain security and quietness and so on. Other than that, we lack of treatment programs a lot. It is run by government sometimes, but mainly by the non-government organizations if they get funding from donors, and it's on temporary basis. So that's how we use it so far. But I'm sure we will come there maybe after another 5 years.
Yeah, it takes really a lot of time to get that process, because as I mentioned in my presentation, only the prison services use risk assessment on a regular basis. And I think even though that's a good thing, it may be even used better because risk assessment is dynamic, sorry, and they do not always have the chance to conduct several risk assessments in one file because of time and a lack of personnel, as you mentioned as well. But now, because of some high-profile cases, you see that things are moving and that politicians are waking up to promote risk assessment. Not always in the right way, I think. But that's we took that moment and we started reacting on everything and talking to politicians and so on. So, but I realized that will take another few years to have it all implemented as it should. Indeed.
Thank you for these comments and clarifications. I could just, as you bring the question, Moretta, from a prison service, I can just encourage you to contact EuroPris as you are members of EuroPris, and we can connect you with another member with longer experience, perhaps in this field, and you can exchange experiences, because there are a lot of pitfalls in this process implementing risk assessment. And my experience from the Swedish context is that if you can try to avoid the most important ones, you can really get something really good out of it, but you can also end up in a pretty bad state if you use it unwisely. So please get back to us. It's time to wrap up the discussion, but we have a few questions left in the chat, I think.
Yes, we actually have one more to Kasia. In your experience, which is in your opinion main risk factor when sex offender obtained large amount of photos and video material of child abuse, and is a computer and engineer with poor social network?
Mm-hmm. Well, that's a tricky question because that's a case I don't know, and it's difficult to comment, which I will not. But I see already a couple of risk factors in this. But I would advise to use a risk assessment tool and to see what kind of risk effect, which risk factors are important to to focus on, for instance, in the treatment and supervision. For instance, poor social network is a risk factor that is included in the stable if you use the static stable acute. And you also have, for this kind of cases, you have the C-port. That's an instrument for risk assessment in cases of online sexual offending, because the static cannot be used for that purpose. But you have to be careful with the C-port because it's not really well validated yet. But it's, to my knowledge, the only tool that we can start using at this moment. Yes, C-port, yes, correctly spelled. And then, for instance, the C-port indicates that you have to look at the content of, for instance, the material you get. So that might be helpful. You're welcome.
Thank you, everyone. I think we should leave some room for the final closing of the webinar. This will be done by Edith Törtz. She's the director of the European Forum of Restorative Justice. If there are needs to see this webinar again, we will publish it on the websites of the organizations of the platform, and the presentations will also be available on our websites. So please, I leave the floor to you, Edith, for the closing.
Thank you very much, Gustav. And I promise it won't be long. First of all, I would like to thank to our presenters, Kieran, Kasia, and Linda, for accepting the invitation and their contribution to this event, and of course all the questions and comments of the participants that made it a very interesting and rich discussion. I think this platform is quite unique in offering a space to share ideas and share about tools and practices relevant for prison, probation, and restorative justice. We see that it's really important to create a dialogue between these fields and professionals from these different areas of practice, but also in academia, of course. And I think for me personally, coming from the field of restorative justice, it was really interesting to see the issue of risk assessment, the issue that we also see in restorative justice, that different tools or different concepts are used in different ways in several countries. And there are no necessarily European standards on everything, which is not bad, of course, but I think the Council of Europe is doing a very valuable work in this respect to provide standards, and I think it's really important for all of us to look at these Council of Europe standards presented by Kieran, which could at least show the way forward. The presentation on risk assessment specifically was really inspiring in a way for me to see that how much one tool won't actually solve the problem unless we know why their tool is there and what we would like to use it for. And it really underlines the importance of actually having a good quality intervention based on the assessment, and also a way of reporting back or taking into account the effects of the actual intervention on the risk. And it should be, I assume, an ongoing process. So of course, in dialogue with the interventions and the professionals providing the intervention and the assessment. And I think this is also interesting from the restorative justice point of view, in a way that I am not aware of actually any risk assessment tools that would take into account a potential effect of a restorative encounter, or would go back to see if such a process, or at least just the preparation to such a process, had any impact on the risks of reoffending. Also, it's really interesting for me that risk is dynamic, and of course is dynamic. So the timing of such a meeting, for example, or a process of restorative justice might be, again, very important. And I think in this respect, effective collaboration and communication between prison, probation, and restorative justice services is crucial, especially in these cases, but I think also in general, in knowing how to support each other's work, and also to make this high quality practice available everywhere. So I hope that this event also contributed to know a little bit more about all the chain of justice who are having victims and offenders as their clients. And we really would like to support the field by offering these kind of events when prison, probation, and restorative justice, and hopefully more other players of the criminal justice system can regularly come together and share their views and practices. With this, I also invite you to our upcoming summer course in Barcelona that was mentioned in the beginning. It will take place in July, the first week of July, when we also will look at these topics more in detail, and you will have the chance to learn together in a mixed professional group with international participants. You can find more information on the three organizations' websites. As Gustav said, we will share the recording of this event that you will find soon on our websites, and we would be really happy to get your feedback through the feedback form that was posted in the chat. And we would like to see how to make these events, which are aimed to give an added value to your work, even more better in the future. So thank you very much again for your attendance. Thank you for our speakers. And I wish you a very nice evening. Thank you.
Thank you for inviting us. Thank you all.
Thank you.
Oh, thank you.
Thank you.
Would you like us speakers to stay on for a moment?